We're going to give everybody just a second to get sit in the room and then we'll get started momentarily. Thank you all for joining today. We'll get started in just a second here. Okay, looks like people are still joining. Give everybody just a second here and we'll get started. All right. Thank you for joining today's webinar, Social Media Addiction Litigation, Ethics, PFS Strategy, and Managing Complex Claims, sponsored by Veris. CLE Ethics credit for this program is offered in California, Illinois, New Jersey, New York, Pennsylvania, and Texas. You'll receive the link to submit for CLE credit at the end of the webinar in the chat and later today in a follow-up email with the presentation materials. There will be 3 CLE code words provided in the chat throughout today's presentation. Please make note of these code words for your CLE credit. You can use the chat to submit any questions you may have throughout the presentation. We'll have time to answer them at the end. I'd like to introduce Mark Evelyn to start today's presentation. Mark.
Thanks, Allison, and thank you all for joining us this afternoon. My name is Mark Evelyn. I am the founder and chief strategy officer of Veris. We are a litigation support firm serving the mass tort and class action markets. I have personally been involved in mass torts for far more years than I want to mention, probably 32, 33 at this point, when I first got involved in the early 90s in the asbestos litigation and have been involved ever since. Our firm manages many large settlement funds created as a result of mass torts over the years. And I am pleased to be joined today by 2 accomplished attorneys with the Lanier Law Firm, a firm that I think reputation precedes them. Anyone who's been following the social media addiction litigation in particular is aware of the recent trial results. And Michelle Green and Michael Axelrod, who are with me today, were part of that trial team in LA a few weeks back that achieved that phenomenal result. I'm going to turn it over to them to introduce themselves, and since she is sitting in the top box in my view, I'll turn it over to Michelle to introduce herself.
Hi, everyone. I'm Michelle Green. I am a senior attorney at the Lanier Law Firm, where the practice centers mainly on mass tort litigation. I've been involved with PFAS cases, Camp Lejeune, and many others, specifically a lot of toxic torts. But in recent months or years, the social media addiction has become a defining focus of that work, including spending several months at trial with Michael Axelrod as part of the trial team in the KGM Bellwether. So I'm very happy to be here speaking with everyone today.
Hi, everyone. I am Michael Axelrod. I've also been with the Lanier firm for a number of years and worked on several other complex and mass tort cases. Spend most of my time doing case management, so my focus of today will be on some of the case management aspects, the fact sheet. But I've also gone to trial with Mark a couple of times and was a part of the trial team as well for the KGM trial this past winter. So good to be here with you all.
Thanks, Michael, and thanks, Michelle. We have a lot of ground to cover. There's a lot of I think great content that we want to deliver today. So we aren't going to beat around the bush here. I think we'll get right down to it. If you could move along to the next slide, and we'll just get right into the meat of it. A litigation update and recent case developments.
Okay, hopefully everyone can hear me. So I want to say up front, this litigation is moving fast. So if you're handling or evaluating a social media addiction inventory right now, the ground beneath these cases are really shifting in ways that are directly consequential to what you do today. So I will walk through where the litigation stands. Michael Axelrod, as he said, he's going to be doing more of the plaintiff fact sheet and casework up, but I'll be going over the major proceedings, the recent developments that matter the most, what the defense is focused on, and what all that means for firms that are carrying active inventories. So as you can see here, the litigation is bifurcated across 2 major forums. So you have at the federal level, the MDL, pending in front of Judge Rogers in the Northern District of California. And there it consolidates thousands of personal injury cases across the country, along with school district claims and cases brought by attorney generals. And then you have at the state level the JCCP, and that is brought before Judge Cool in Los Angeles. And that has really been the trial proving ground. And that is where the first case has reached a jury. And that reality has changed the litigation calculus for everyone involved. And if you can go to the next slide, as I'm sure everyone knows on this call, you have the defendants or the major social media platforms, right? So Meta, which is owned by, which owns Instagram and Facebook. You have Google, the parent of YouTube, Snap, the company behind Snapchat, and TikTok, owned by ByteDance. And these are not monolithic defendants, right? Each platform presents distinct design choices, distinct internal documents, and distinct litigation postures, and your case strategy, should reflect those differences. And if you go to the next slide, I can kind of talk about the core allegations, what these cases are, and also just as important, what they're not. The theory driving these cases is product design, specifically the features built into these platforms, not the content that appears on them. So we allege social media companies engineered their products in ways that are inherently harmful to young users, not because of what third-party post, but because of the deliberate design choices that were baked into the platforms themselves. And this distinction is both legally and strategically critical. By anchoring our claims in the design defect rather than the content, we've worked to avoid that broad immunity that really shielded so many of these companies under Section 230. So courts have largely sustained that distinction, which I will come back to, but how claims are framed at intake can really affect how they hold up downstream. So it matters that your firm has this right. And this distinction also matters practically. Parents may come to you and focused on content and say, my child saw self-harming videos and then hurt themselves. But what we are pursuing is the addiction to and the compulsive overuse of the platform itself, not what is said on the app. So a mental crisis may be a consequence of that addiction, but it's not a standalone claim. And claimants really need to understand what the litigation is and again, what they're not. And they need to hear that clearly from you. And the specific design features that I'm talking about here are infinite scroll, autoplay, engagement notifications, users waking up in the middle of the night because they have a notification and then, affects their sleep. The inadequate age verification processes, absence of warnings, the absence of labels or unfiltered or edited images. And then you have theories of failure to warn. Platforms had internal awareness of the risks that their products pose to adolescent users, and they failed to adequately disclose or address those risks. So you also have that as well. And the harms are, encompassing depression, anxiety, eating disorders, self-harm behaviors. So establishing individualized causation is one of the most contested issues in these cases and will require substantial and well-supported expert evidence. So if you go to the next slide, just quickly on the key legal battleground. So on the defense side, Section 230 arguments have really been largely rejected in this context, where courts have drawn a clear distinction between liability for hosting content versus liability for the platform's own design decisions. This is doctrinal development that makes this litigation viable. There's been Daubert challenges to plaintiffs' causation experts. That has been a major front. So the defense has systematically attacked psychiatrists, behavioral health experts, epidemiologists, arguing that the science is insufficiently established. So the key lesson is that your causation proof needs to be airtight and claimant specific. So general population studies are a starting point, but it's not a finished line. And then we have the RKC matter, which is the second bellwether that has not gone to trial yet, and that's starting in July, and that's proceeding worth watching closely. If you go to the next slide, I can kind of talk about recent developments, what has happened. So the most significant development is that these cases have gone to trial, right? And that's not a small statement. We have moved from a theoretical litigation into a phase where juries are hearing evidence and they're returning verdicts. And that changes how you evaluate, how you prepare, how you advance these cases. And on March 25th, the trial team, including Mike Axelrod and I, secured a $6 million verdict for the KGM client, the first completed bellwether trial in the JCCP. The Los Angeles jury found Meta and Google liable for designing platforms whose addictive features substantially contributed to the harm suffered by the plaintiff, and they allocated 70% to Meta and 30% to Google. The plaintiff had used YouTube from age 6, Instagram from age 9, and the evidence there showed the features such as infinite scroll, such as the algorithmic recommendations, and autoplay really did contribute to her anxiety, her body dysphoria, her depression. And punitive damages was also awarded as a $3 million punitive damages. So, and also one of the things that made trial so significant was what came into evidence. There were, slides prepared by Meta's own researchers stating that teenagers blamed Instagram for increases in anxiety and depression. There were YouTube internal documents similarly showing awareness of how autoplay and recommendation systems really drove compulsive viewing, including in minors. And if you go to the next slide, I'll touch on just ethical considerations in social media cases. And because I think it's undersold in conversations here about mass tort litigation, and it's especially important here. Sorry, if you go to the one, should be the next slide. So ethical compliance in this context is it's not just about avoiding bar complaints. The obligations around accurate advertising, competent investigation, and honest client communication obviously are very important. So if you go into the advertising and claim intake, here we go. So our firm does not do advertising, but social media addiction litigation has attracted enormous advertising spend. And that advertising creates both a funnel of potential claims and significant professional responsibility exposure for firms. And in the mass tort context, that means, we can't promise outcomes, we can't overstate claims or we cannot imply that anyone who views social media and experience mental harm automatically has a viable case. And that point matters because the causal story in this litigation is genuinely complex. So social media use is near universal, and adolescent mental health challenges are widespread. So the overlap between those two populations is enormous. And any advertising that suggests the mere overlap creates a claim is both misleading and ultimately bad for your inventory. And intake processes carry the same obligations, pre-screening conversations, intake forms, triaging calls. It needs to be designed to surface accurate information, including facts that may work against causation, of course. Claimants whose mental health treatment predated any platform use are candidates for honest evaluation. So filing a claim for someone whose records will not support a theory is a disservice to that claimant, to the litigation as a whole, and to your professional responsibilities. If you go to the next slide, talking specifically about representing minors and vulnerable individuals. So the claimant population in this litigation is a vulnerable one, right? Many are still minors who have experienced serious mental health harms and families who are often still living with the aftermath of that. And many claimants and families will share deeply painful experiences during intake. A child who, began cutting after consuming harmful videos, a teenager who was hospitalized, families that watched their child deteriorate. And those experiences are real and they deserve to be acknowledged with compassion. But at the same time, you must understand that the harm we are pursuing is the addiction and the compulsive overuse. So, as I said earlier, a self-harm episode or a mental health crisis is part of the story, but it's also a consequence of that addiction. It's not a standalone claim. And claimants need to understand that distinction and feel heard, even if you have to redirect them towards the legal framework. And claimant support infrastructure in this litigation has a few components that sometimes are underinvested in. And first, just obviously communication with your clients, how often your clients hear from you, what they hear, who sends it. in high volume litigation with long timelines. Clients usually, if they go silent, sometimes they have loss in confidence or disengage or sign with someone else. So a regular cadence of honest conversation, of course, is required. Second, trained intake staff who know how to handle disclosures of trauma and abuse is important. And third, a mental health kind of referral pathway in the sense that you are not their therapist and your team should not try to be. When a claimant or a family member is in acute distress or when the documentation process reopens wounds, refer to them to clinical support. Again, you are not their therapist. And recognizing where that role ends is not a limitation. It's really part of representing these clients responsibly. If you go to the next slide, please, I will talk about just managing sensitive mental health and personal history information. So these cases involve some of the most sensitive personal information that exists: psychiatric treatment records, self-harm histories, sexual abuse histories that may intersect with platform facilitated harm, educational records, communication between minors and other users. And your confidentiality obligations around this are significant. HIPAA authorizations need to be properly executed for medical record collection. In coordinated proceedings, you have common benefit discovery protocols. But there's also a litigation strategy dimension. So not every piece of sensitive information in a claimant's record is going to help you. But you have, defense counsel will use those prior mental health treatments and family history and pre-platform diagnoses aggressively to argue this alternate cause. And your job is not to hide that information. Disclosure obligations are real, but to understand it, to put it into context and prepare your claimant and the case narrative around it. And this is where reframing becomes essential. In the KGM trial, we were confronted with this challenge head on. Rather than conceding that pre-existing vulnerabilities diminished KGM, our client's claim, we argued the opposite. We flipped it on its head and said that, every prior stressor, family instability, earlier mental health issues, all of those, a difficult home life, it made the platform's conduct more culpable, not less. These platforms were not designed for the idealized resilient user. They were designed to maximize engagement, and they did so most effectively on the children least equipped to resist. The most vulnerable users experience the most harm, and that is precisely why they deserve the most protection. And this is what was echoed in trial. And Mark Lanier, who was the main attorney litigating this case, had this metaphor of the lion and the gazelle. And the lion, doesn't go after the fastest gazelle; it goes after the weaker gazelle. And a defendant cannot engineer a product to exploit psychological fragility and then point to that same fragility as a defense. And that argument really resonated with KGM. And it's just, I'm just saying this as it's a framework worth carrying into every case where that you have, where, counsel might try to weaponize a claimant's history against him or her. And if you go to the next slide, I'm almost done here. So the duty of competence in technology. So in social media cases, competence means more than just knowing civil procedure. You need to understand the platforms well enough to explain it to a client, and how an algorithm works, what a streak feature does to adolescent behavior, what the internal documents are for these defendants. And you need to meaningfully understand how it can manifest in treatment records and kind of reading between the lines. One of the most important and frequently underestimated skill in evaluating social media claimants is learning to read treatment records for what they don't say as much as what they do. So young, boys and girls are not rarely going to walk into a therapist office and say, I think Instagram is making me depressed. They will present with insomnia, irritability, academic decline, social withdrawal. You'll have parents report that they've changed, or pediatricians noting mood symptoms and refer out. So the causal thread to social media is almost never explicit in the record. But that silence is not a weakness in your case. It really does reflect how adolescent psychopathology presents. So you're kind of looking for that temporal architecture. And I think that it's an important one to be aware of. So what makes a claimant's case strong is not the absence of those factors, right? But the ability to show that this trajectory changed, that the change was disproportionate to any pre-existing vulnerability. And that pattern of compulsive use, sleep disruption, social comparison, self-image injury, that's what specifically what the platforms were designed to produce. And in KGM, that tension played out in the way the KGM trial, it played out exactly in any well-developed case, right, where her records did not present a clear narrative of the social media causation. Her history included some family issues and things like that. And the argument is not, but for social media, she would have been fine. It's social media transformed a manageable vulnerability into a crisis. And the defendants knew that was approximate, that was a foreseeable outcome for her. So the practical implication for record review is that you should approach each file kind of asking, what was his trial's baseline? And when did that trajectory change? And look for an inflection point. Look for what providers noted but didn't connect, or things that child told platforms through their behavior, like the hours of use, the content consumed, the features engaged, and the platforms, logged even when no clinician was watching. So those behavioral footprints are very important, and often where the strongest cases are built. If you go to the next slide before I give it over to Michael, just in the mass tort, the quality of your inventory is, collectively affects every case in it. So overscreening means casting a net so wide that you are assigning cases with no realistic pathway to recovery. And in a litigation where causation scrutiny is intensifying and courts are actively managing case quality, overscreening can create inventory that costs money to carry and damage your practice when those cases are resolved or dismissed at below cost values. And then you have the problem of overstatement, meaning claims, injuries that the records do not support. And you don't want that, right? So if the records showed a prior diagnosis or family history, the case requires honest evaluation, not reflexive filing. And underdeveloped claims, then you have a problem. You have the opposite problem, where there's cases that have genuine merit, but that have not been adequately investigated to prove it. If you have a claimant with compelling facts and a strong medical record, but you haven't collected those records, or documented the PFS properly, you're really leaving value on the table and potentially missing litigation deadlines. And with that, I will give it over to my colleague, Michael Axelrod.
Awesome. That was really great. Thank you, Michelle. A few of the topics that I have to cover will overlap with some of the things Michelle said. So apologies in advance for that. They are important concepts, which, I don't think it'll be a problem to restate. Um, if you are involved in this litigation or getting into it, you will soon find that this is one of the most extensive and comprehensive fact sheets that there ever has been in any mass tort case. You don't be shocked to find that it is quite long. I think it's 81 pages, and it includes, authorization forms that need to be provided, which allow access to various types of records. And we'll go through that soon. But you can go to the next slide, please. The the fact sheet is important, not just for the defendants to know about the case, but for us to have a good sense of what it is that we're dealing with. And so it's important that we do a good job in preparing it, serving it, and doing everything timely. Not only is it a requirement of the litigations, for your clients to complete them and serve them within the deadline. But it's something that we will use as plaintiffs' counsel and defense counsel to get an understanding of what it is that the inventories are about and the types of cases that exist. And so, once you submit these fact sheets to MDL Centrality, which is the company managing and housing all of the fact sheet and data, the plaintiffs and defense leadership will look and use that data to determine representativeness of the bellwethers, for example, or use that data for settlement discussions, which will hopefully guide and lead to a resolution of the majority of the claims. So you shouldn't just treat the form or the fact sheet as a form to fill out, but as a strategic document that defines the quality of your cases and inventory. Um, Inconsistencies will be used against you and pointed out by the defendants. And it's not likely that many of the cases will see trial or be tried, but there is a possibility that there may be additional bellwether pools and cases that are submitted now and fact sheets that are prepared could be used to determine those pools. We've run into the problem in the bellwether pool of having inconsistencies used against us. The cases that were set for trial had multiple iterations and amendments of fact sheets, and although it turned out that we could, explain those things, there is an explanation for why a plaintiff might need to amend or add information. Memories are evolve and change, and the recollection can occur after initial fact sheets are prepared, but as much as we can, you want to have the fact sheet as consistent and complete as possible. You can go to the next slide. Like I mentioned at the outset, the fact sheet is extensive, and so you will be asked for or the client to provide a significant amount of information, including almost an entire history of their background, their employment, their where they've lived, all of their education, and all of the medical treaters that they have seen. Many times, your client will not recall all this information. And we'll get into that in a second. But what we like to do is stage these interviews to collect information over time and separate them into categories of information. We also like to preview for our clients what it is that we're going to be gathering on the calls that we have with them, so that they know and can be prepared and can look up and find out or think about the types of information that we'll be asking them for and provide it. And these are some of the types of information that the fact sheet does ask for. It also asks for, the amount of social media used, and we'll get into that in a second, pitfalls that you may see when discussing the amount of social media that any individual claimant has used, but also the types of damages that the claimant is seeking. And like Michelle was saying, you have to sort of help the claimant understand what it is that this case is about and the types of damage that we're seeking. And we're not trying to say that there isn't other ways to be harmed by social media, including, viewing harmful content. And some of that should come out in the fact sheets, including discussions of bullying, sextortion, or other types of interactions with third parties. And that's important to note, but also to highlight the types of features which are platform specific. And we'll get into that in the next slide, which we can go to now. Each defendant has their own appendix that needs to be completed, and it has a list of the different features that the platforms have on there for plaintiffs to engage with or use. And so it's important to try to explain to the client that this is one of the most critical aspects of the case, and so for them to recall the specific features that they were using during their time on each platform. Many clients are still using these platforms. They are addicted, of course, and and that's another thing that we try to, balance is how much should we tell the client what to do with their social media use. And Michelle is right, usually referring them to their mental health provider and finding a good pathway to reduce or stop using social media is sort of in the arena that the mental health professionals should be addressing. But we need to collect and understand how it is that our clients were injured and document that. And the fact sheet allows us to do that. But also you can see that each individual defendant has different sort of features, some of them common, but they're not all identical or the same. And the liability story and knowledge of the harms individually varies between the defendants. You can go to the next slide. Ingrid, next
Yeah,
slide.
you need to move it.
Anyways,
We seem to be experiencing some lag time.
it's okay. So I think the main point I'm going to make on the next slide, I'll start talking about, is just consistency between the various file documents, the fact sheets, the complaints, all of that information should be as consistent as possible. Those are the types of issues that came up during the bellwether discovery process that really tripped our clients up in discovery and in their depositions. They're not sophisticated storytellers, so to the extent that you can prepare them by having the document be consistent and for them not to have to explain their inconsistencies, I think that'd be a key thing to focus on during the fact sheet preparation stage. It shouldn't be rushed. You should take your time. You have 105 days in the JCCP at least to prepare the fact sheet. Some firms have started that process before filing to collect the information, have it ready to go and finalize the fact sheet as the things move forward with the filing of the case. It's not always possible. A lot of claimants may be turned off by having to fill out and provide an extensive amount of information ahead of the filing of their case. And I can understand that, but if you can explain to the claimants that this is the best way to achieve maximum value in their case by being as open as possible about their usage and their history, letting them know that this is all confidential and maintained under the protective orders in the case. A lot of clients have a concern about all of this being publicized, which it won't be. Of course, the trials are open, and that has been a concern for our clients, and we were able to use pseudonyms for at least some of our claimants, at least those that brought the claims before they turned 18. But how are we doing, Ingrid? Okay.
She's still screen is still
Struggling.
frozen.
Okay, well, let me pull it up on my screen so I can see what the slide is.
Uh-oh, looks like we might flip around for a
There.
second while her
Okay, yeah.
screen
So I mean,
reloads. Sorry about that.
this is all the stuff I've been just saying, so I think we can skip to the next slide.
There.
Your task is to collect and support the injuries that your client is alleging. So that means mental health records, and Michelle touched on that. You will also be providing authorizations to the defendants to collect additional information. You're free to collect that if you want. I find it better to let the defendants collect all of that. And they're likely not going to do it until the case gets to a bellwether posture. So, as long as you have records that document the injuries, that your claimant is alleging, then I believe that should be sufficient for at least the fact sheet process, which you do have to produce the records. All of those records are produced on MDL Centrality, which many of you probably have used with other mass torts. Next slide. I think I've already touched on this during the delay, but just make sure that you're making an effort to compare the different documents you have, that they're consistent between the medical records, the complaint, and the fact sheet. I find it helpful to first prepare a sort of timeline myself, and then use that when going over the fact sheet with the client to prepare it, and before it's finalized to compare it to make sure that the timeline matches the way that the fact sheet narrative is developed. Next slide. Okay, I wanted to focus one area which I think is important, not just to the litigation, but for plaintiffs' lawyers to be able to educate their clients. And shame on the defense lawyers for structuring the fact sheet this way. If you're on this call, that's my one note to you. I think it's unfairly structured in a way to make it so that plaintiffs don't really accurately or adequately explain their usage information. For those of us that have been involved, we know that the platforms don't do a good job tracking actual usage. They don't retain all of the data over the entire period of time that our claimants use their platforms, and they don't even know who is using their platforms most of the time. They don't provide us exact information on our clients' usage themselves. They rely on our clients to tell them their account names, their emails, their phone numbers. And that's just not always possible and difficult for minors, especially who've used different account names over time, who've used their friends' accounts, their parents. They're accessing these platforms without emails, like with YouTube, that doesn't require anyone to log in to use their platform. The fact sheet is structured in a way for usage to be explained or accounted for or in three different ways, and they're listed here: average use, peak use, and nightly use. And sometimes our clients kind of confuse those things. And we've run into situations where you've had more than 24 hours of usage in a day, which I think is actually okay, as long as you explain in your fact sheet that your client is using these things concurrently. They're switching. I don't know if you've seen people use social media these days, or at least minors, but it's like rapid fire. They're switching immediately from one to the other, like constantly. It's almost sickening to watch. I don't know if you've seen it, but so it's important to just highlight that these are different pieces of information. And it's okay that they add up to more than 24 hours a day, but you need to put some sort of note in there that says that, so that at a deposition, when your client is shown that, they can see it right then and there and say, oh yeah, it's because of this. Because I've run into the issue where the client's just confused and says, that's not right in a deposition when it actually is right. Next slide. This is the 24-hour problem. So I was just talking about that. You can go to the next slide. Another problem is that the usage information is not a snapshot. It's not one piece of information at one time. What we found is that many people change their usage patterns over time. And that tends to be that, maybe they'll start with Facebook as their primary, or Instagram, shift to Snapchat, and then, now TikTok's their primary usage platform. And I sort of use this slide to illustrate that, between different ages, you'll see different types of usage. And I think it's important to try and highlight that on the fact sheet. If you just ask the client, what is your average usage? They're not going to know what you're talking about. So help them explain to them that, okay, between 11 and 13, how are you using the platforms? How many hours a day? What was the average use? What about 14 to 15? How many hours a day? What was your peak usage? How about at nighttime? Break it down over periods of time to help your client give the best possible and clearest answer. Because if you just ask them, what is your average usage? You're not going to get a good answer, a good response, an accurate response. It's important to understand that shifting patterns shift over time, and that's true for almost everyone, including probably for all of you who've used platforms. Next slide. I think this is on Mark.
I think it is my turn, and I know we still have some other content, Michael, that you wanted to cover for us this afternoon. So I will try to move through this as quickly as possible. If you could move to the next slide. I just want to cover, because what Michael just walked us through, the plaintiff fact sheets and the how involved they are, the nature of the data that is required to be submitted here into MDL centrality is essentially a gold mine for the application of predictive analytics. And this is something that both parties, the data is accessible to both parties in this case, and this is becoming the norm in mass torts. So I just wanted to talk a bit about the benefits of predictive modeling in managing a mass tort. What I mean by predictive modeling is the application of statistical and machine learning methodologies to large data sets in order to determine patterns in evolving litigation based on both that current and past historical data that would help firms involved in leadership on both sides of the V to anticipate changes in the direction of the litigation and plan their strategies accordingly. My firm has been involved in building predictive models in multiple areas of litigation, and these models typically involve core inputs that fall into certain broad categories. We have the claim characteristics. That's the details that are going to come out on these plaintiff fact sheets. The nature of the alleged injuries, how the claimants were exposed to the harm. In this case, their usage patterns, which platforms they used, how long they use those platforms on an average daily basis, shifts in those patterns of usage over time, jurisdictional characteristics of the claimant population. In addition to that, these models also take into consideration what I call temporal signals. That is, how quickly are cases being filed? How many are being filed over the course of an average week, month, quarter? In other words, is the case in an aggregation phase where we're seeing more and more cases being filed over time, or are things slowing down? Um, Procedural factors. What are the outcomes of bellwether trials, motion practice, orders entered by the court, the requirements of case management orders? All of these are signals in terms of what courts are thinking, what juries are thinking, that could impact the value of cases, how you begin to segment the population into higher and lower tiers of damages. And then the economic drivers. Such as the wherewithal of defendants to pay. Here, I don't think we're dealing with defendants that are at risk of bankruptcy anytime soon, but in many mass torts, we do have to factor that into modeling. What are these cases potentially worth? And the factor in the ability of defendants to pay those values. What these models give attorneys kind of forward-looking estimates of the mix of cases, the volume of cases, the mix of cases in terms of damages and injury tiers, and what the timing, how you may plot your strategy to find the pressure points for achieving a fair outcome in settlement negotiations. These models are not perfect. They're not going to predict the exact value of cases when they settle, but they will help you narrow the scope and the range of uncertainty. And they can also be used to give early warnings of inflection points in the litigation. As I mentioned, acceleration in case filings is perhaps an early warning sign to the defense that there will be more and more pressure to settle. The declines in case volumes may be a signal to plaintiff firms to begin to put posture to negotiate a settlement sooner rather than later. If you could move ahead to the next slide, Ingrid. So the main uses, I already touched on this to some extent. Plotting on the plaintiff side in particular, your portfolio or your capital strategy. How are you going to deploy capital to acquire more cases or acquire the right, what you think are the most valuable cases in the litigation? The calibrating your advertising spend, not just in terms of how much advertising spend might be necessary to achieve certain number of cases, but where and when to place that advertising. What are the right channels? What are the right times to reach out to potentially impacted individuals? And then the litigation and negotiation strategy I already touched upon as well, anticipating those settlement pressure points and quantifying the impact of developments in the litigation so that the parties can identify when conditions are favorable to either acquire more cases or shift into settlement mode. And of course, it gives a lot of risk management tools to leadership on both sides. Slower than expected filing patterns can indicate there may be some downside indicators to the litigation, adverse rulings from the court, evidentiary rulings, etc., and jurisdictional bottlenecks, helping identify what are those bottlenecks that could potentially slow the litigation and require a shift in strategy. The results of all this are making decisions based on data rather than anecdotal information and what I've often seen in mass torts, optimism bias. A big bellwether verdict does not indicate that every case is worth that value. It's a signal of what that jury was thinking, and the facts presented in that particular case doesn't necessarily indicate that every case is going to be a bell ringer. It's a data point. Um, with that, I will turn it back over to Michael to finish out um, the materials we have.
Okay, great. Thank you. I'll go quick because I want to leave some time for questions. And some of this has already been covered. You can go to the next slide, please, Ingrid. So we've talked about this already quite a bit, that there's actionable claims and those that really we can't make or base our claims on. However, they are important. So, you do want to explain to clients, of course, what the theory of the case is, but ask them and elicit how they were harmed otherwise, including by content. It's important because one of the features of an addiction is knowing that it causes you harm and doing it anyways. So, if you can say, oh, I was harmed by bullying or seeing, content that included violence or of suicide or of self-harm, and I still went and used the platform, even though I knew that was causing me problems, that's an important fact to elicit and document. And it should be discussed both in the fact sheet and between you and your client as far as, when preparing for future depositions if those do come up. Next slide, please. So again, we've already covered a lot of this. You do want to gather and collect the mental health records that support your case. You do want to have open-ended discussions about them with about their history, about their social media use, and you do want to educate them about how the platform works and it was designed. You don't want to discourage them from telling you about other harms that they've suffered throughout their life, other psychological illnesses that they may be facing and or dealing with. You want to have them tell you how they use the platform, which features they use, not just assume based on their age, what might be typical. Next slide. Again, you want to disclose and be honest about the difficulties in your case and deal with them. They're an important part of the case. The more vulnerable your client is, it might seem like that's a difficult case, but in fact, like Michelle said, those are the people that are preyed upon the most by these companies. Those are the people that are most susceptible to the features that cause addiction. And so you need to identify and be upfront with all of those types of issues in the case. The records will explain, will show what your client has gone through for the most part. And so document all that in the fact sheet, and the records will tell the same story. Next slide. Wanted to touch on one more thing. I know we didn't have this in the agenda, but in addition to the fact sheet, there's also the plaintiff preservation form, which is sort of an addendum to the fact sheet, but it is a standalone item that needs to be produced. And that is where your client identifies all of the ways that they accessed the defendant's social media platform. So they're going to ask you for the client's used information, like contact information that they use to access the accounts, emails, phone numbers, but also URLs for the accounts that they've used. Also their account names, if they remember them, third-party accounts that they may have used, if they use their friends' accounts to access platforms, parents, etc. They'll want to know any bad actor account information about those that may have influenced them or been, made harmful conduct separate from what's happening on the social media platforms towards your client. They'll want to know information about that in the preservation forum. So that's also how the defendant's companies know to save and preserve the account data that they're not necessarily keeping. So you need to make sure that as much as you can, you identify all the accounts or the ways that your client used the social media platform so that the defendants know and are on notice to preserve the account data. Otherwise, they won't. There's been a long process, a negotiated process with the defendants, and this is how it's been settled in order for them to meet their preservation obligations for the litigation. I think next and maybe last slide. Yeah, so I just talked about this. This is basically all the principles for the PPF. You should collect all the accounts that you can, including third-party accounts, document bad actor accounts, This is for your client's sake to preserve all of their account data for possible future litigation. We did use a significant amount of account data in the KGM trial. One of the best and most I think notable or like exhibits that we think affected the jury was actually like a huge 5 by 10 banner that we generated with all of the selfies that KGM had posted on Instagram. It had thousands of selfies. So that was something that we could have only obtained if we, with the data that we got from the preservation of the account. Next slide. One more thing I wanted to note beyond the fact sheet is that you should explain to your client their own preservation obligations before you file the case. You should tell them, we're going to be filing your case. You have to preserve all of your account data. You cannot delete any posts. You cannot delete any comment. You cannot reverse any like. Has to all stay there. It's kind of, it may be off-putting, I think, to some of our clients, and they may not want to proceed, but you do have that obligation at least to instruct them. They also have to keep their phones that they use to access the defendant platforms. If they're gonna, they can keep using it under California rules. You don't have an obligation to stop using it, but you cannot destroy or get rid of the phone. There is a natural destruction of account data that happens just by using your phone, and that's allowed under the rules in California, at least. The phones will cycle through some of the phone memory over time, and so there is a natural destruction of data. But they shouldn't get rid of their phone entirely. If they're going to trade in their phone, they should contact you. There are ways to do an image of the device. You can image the device, return it to your client, then they can trade in their phone if they want. Some firms are buying new phones for their clients when they need to trade them in and collecting the accounts, the phones that they use to access defendant platform accounts. It's quite complex, unfortunate, and a real hurdle for pursuit of these cases, but something that you should be aware of. And the last thing that I want to stress and is important for everyone to know is that AI chatbots, that discussions with AI chatbots can be discovered. It is discoverable and it's come up. It's a problem. You should advise your clients. They should not be having discussions with AI chatbots about their case, their claims, or really anything to do with their harms if they can help it. I know it's difficult, but I at least would advise you to advise your clients of the risk of having those discussions with AI chatbots. I've told my clients it's the same as taking your attorney-client privileged confidential information and putting it on your window of your house for everyone, all your neighbors to read. And with that, I think we can close with questions if you have any.
Great. Thank you, Michael, and thank you, Michelle. We covered a lot of ground here. I believe there's only one question so far, which was actually in the form of a comment in the chat. But I think it leads to a very interesting question. Somebody raised the fact that there are similar issues with online games that have similar potentially addictive features built into them. And I know there's developing litigation in the area of gaming addiction. Is there significant overlap between the social media litigation and the gaming addiction? Do you see those two eventually converging into around common issues? And I'll leave that to either of you to address.
I don't know much about the gaming addiction cases. I know they're out there. I would say that there's a difference between platform in general, whether it's social media or gaming use by adults and children. There's the adult brain is fully developed and able to manage these types of features in a way that the child brain is just not. And so one of the biggest claims that we have is that the targeting of children themselves, the design of the platform with children in mind to get them hooked. And the defendants openly discuss this and acknowledge internally, at least, that that was their intended purpose, was to hook young adults and minors so that they can become lifetime users of the platforms. And I assume that's a similar
Yeah.
feature possibly of gaming.
Yeah, that's all I would add is I think it's the same behavioral design playbook, right? Both industries borrowed from the slot machine psychology, this variable reward schedule and achievement loop and social validation mechanics. So I think similar to what Mike said, that is a theme, I think, in both cases, for sure.
Hmm. Well, here's another interesting question that just popped into the chat. Based on the cases that, as they've developed so far, um, around the design defect theory, have you seen any behaviors on behalf of the defendants where they've shifted and updated the design of their applications or their platforms?
Um, winning, we've seen some ads about one of the arguments in this case was parental controls and the lack of parental controls. And I have seen some ads that they are trying to make some new kind of parental control um, feature on the apps. But I think that does winning a case with these claims, does anything happen with that? I think just the fact that it's, getting into people, the public is getting more aware of what's happening here, I think is a big, is really a big help to try to make some long-term change within these apps. But I have seen, again, some types of like parental control features that are, being advertised about. I don't know, Mike, if there's anything else that you can
Yeah, here's what I would
think of.
say. There is clear evidence, and we presented this at trial, that the changes that the companies have made over time have been a band-aid and a PR function really, as opposed to actually taking the steps that they know after conducting internal studies, after consulting with experts that actually made suggestions on what should be done to solve these problems. They don't take those steps. Instead, they take steps that just make them look like they're taking steps to improve their platforms. Meta has introduced teen accounts, and the insiders, the whistleblowers who know about these things will tell you that these are not sufficient. The problems are still there. You can easily get around most of the functions that they've introduced, time reduction features, parental controls. All of these actually are just non-working solutions to a problem which they view as a PR issue as opposed to an actual problem. And they do know, by the way, they do know that this is a problem. And they've instead of calling it addiction, they've retermed it problematic use. And internally, they will refuse to and shut down any conversation that involves the word addiction, and will say it's just problematic use and it's the user's fault or the parent's fault. And one thing I've run into a lot is parents feeling guilty and saying, "Well, I really should have done this or I should have done that," or they're feeling shame by comments they see online or talking heads on TV. And I tell them that they shouldn't, and that those talking heads and those commenters are wrong. There's nothing that parents could have done really that's different that would have prevented the harms from occurring, because the platforms have just been designed in a way that you can get around all of those features, and the parental controls are essentially useless.
Hmm.
Yeah.
Well, one other question I'll throw out there since we have a few minutes remaining. Michelle, you talked early on about the core allegations here, the design versus content, and really focused on four different aspects of the design that are at the heart of these cases. Is there any one element of the design, any one of those four categories that you think is more compelling in having convinced the courts and juries that this is really a design case than the others, or is this a sum of the parts is greater than the whole situation? You can't really untangle them.
I think, we can, so explaining the distinction, I guess, first is, Section 230 will immunize platforms for decisions made in their capacity as a publisher or a speaker of third-party content. What it does not immunize is the design of the product itself. And the Ninth Circuit has really engaged with this meaningfully. The district courts in both California and the JCCP and the MDL have largely held that line. But so I think that again, all of these it's very case specific. In KGM, we found that The filters, different features that the app, like the filters, was extremely stressful for her and her mental health. Also, the notifications on the apps waking her up in the middle of the night and not being able to sleep. And we saw that in medical records. I think all of these are hugely important when it comes to the features of the apps. And really, I think that distinction has been made, and the courts have largely, honored that distinction as far as the design versus the content, for sure. And I think, we've watched that unfold, and the legal framework really has solidified around this design defect theory. Courts have largely really accepted that, plaintiffs challenge how an algorithm was built, how notification systems were engineered, how platforms are really designed to maximize engagement and expend at the expense of the adolescent mental health. And that is not content. That is product liability. And that distinction has been the load-bearing wall of this entire litigation.
One more question that's popped into the chat. Are there any collateral estoppel arguments where the company has lost a claim that their design is defective?
I don't think so. I think, unfortunately, each of these claims are individual, and there's not like a decided case law on the topic yet. I'm certain that, these claims are on appeal. I'm certain that we'll get some good case law in the future, unless they settle, which I would suggest they do. And we may be able to use those. Although I think at least for the courts that we're in, Judge Gonzalez, Rogers, and Judge Cool, I don't think, if they're presented with with a similar case on this topic, I don't believe there's any alternate ruling that could be expected, although I would expect at least the briefing on that topic.
Right. Thank you. And I think we're coming up on the time. Um, I want to thank Perrin once again for organizing this webinar. I hope everyone who's participated and joined us today has found this useful. And thank you, Michael. Thank you, Michelle, for this incredibly informative update on the state of this litigation. Look forward to seeing where this goes next. I will hand it back to Allison to take care of any final housekeeping.
Can I say one more thing, Mark?
Oh, sure, sure.
Yeah, and I'm not sure if this is allowed, but I want to plug our conference, which is coming up in June, the Linear Trial Academy. Michelle and I will be there. If you want to meet us in person, we can answer your questions there. I expect that Mark will focus greatly on the way that this trial was presented, the actual mechanics of putting this trial on, and the different types of tools that we used. And he usually will do that each year for the cases that he tries that year. And so if you're a plaintiff's lawyer or staff, you're welcome to join. And I would recommend you come to the Linear Trial Academy in June. And hopefully we see you there.
Okay.
Thank
Well, thank you all for joining us today. Thank you to Veris for sponsoring this webinar, to Michael, Mark, and Michelle for leading such an engaging discussion. Attendees can look for an email later today with presentation materials and that link to apply for CLE credit. Again, the three code words today for CLE were clients, quality, and account. Thank you all so much. Have a great afternoon.
Thank you.